morning, or good afternoon, wherever you're zooming in from, and welcome to our conversation about the importance of diversity to innovation from the perspective of the judiciary. I'm Hildy Bowbeer. I have the honor of serving as a magistrate judge in the United States District Court for the District of Minnesota, but I also have the honor of serving as the moderator for this amazing and diverse panel of judges. By way of introduction for me, I've been on the bench for about 7.5 years. I started my career as a trial and appellate lawyer, specializing in product liability litigation, and then spent 17 years in-house at 3M Company managing intellectual property and product liability litigation. While I was there, I had the opportunity to work with the IPO Education Foundation's 2021 honoree for Executive of the Year, Ivan Fong. So it was a particular privilege to have had the opportunity to work with him while I was still at 3M. In each of those roles, I've had the opportunity to see firsthand the mission critical importance of a commitment to diversity and inclusion, and particular to our conversation today, the return on investment, if you will, of diversity and inclusion when it comes to innovation. Whether we're talking about innovation in the traditional IP sense, or whether we're talking about innovation and creativity in the courtroom, the workplace, or in the boardroom. So our conversation today is going to focus on the perspective of the judiciary, not overlooking the distance that we ourselves have to travel in this area. But I'm privileged to be joined by judges who represent federal, state, and agency roles in the judiciary at both the trial and the appellate level. I've got a few questions for them myself, but I'd also encourage you in the audience to use that Q&A functionality on your screen and pose some questions to us. If you'd like the question directed to a particular judge, let me know that. If you're directing the question to anyone on the panel, that's cool too. But we will, I'll queue up those questions for our panel, and we'll get their responses as they come. But let me start off by asking our panelists to introduce themselves, and maybe to include a little bit in their introduction about something in their experience that's helped to shape your commitment to diversity and inclusion in the profession. So let's start with the Honorable Kathleen OMalley.
Thank you. I'm on the federal circuit right now, which I think people generally know. I've been there for 11 years, a little over 11 years. Before that, I was on the district bench in Cleveland for 16 years. So I'm an Obama appointee, a Clinton appointee, and then before that, I was the chief counsel and chief of staff for the Ohio Attorney General, doing my public service work there. And for about 12 years before that, I was a practicing lawyer. But I started my career with the best job ever, which was being a law clerk to the Honorable Nathaniel R. Jones, who I think left a huge impression on me. He stayed my mentor my entire life. He was an icon of the civil rights movement. He taught me all about the importance of diversity, and really was the one who told me at the time I sought the district court bench that I had to do it. And when I asked him if I was too young, he said, there are not enough women who are seeking these spots, not enough trial lawyers who are women, and you're at the perfect time. You're at the right place at the right time. And if it wasn't for him, I wouldn't be on the bench. If it wasn't for him, I wouldn't be who I am probably today. So that's probably the most important influence in my life as it relates to the importance of diversity.
Thank you, Judge OMalley, and thank you for being a part of the conversation today. Let's turn next to Justice Tanya Kennedy.
Good morning, good afternoon. My name is Tanya R. Kennedy. I initially worked as a trial attorney for the New York City Law Department Corporation Counsel. And after working as a trial attorney, I then was promoted to a supervisory position in the pretrial unit From my work at Corporation Counsel, I became a court attorney to a judge here in New York. I became a judge in 2005, where I ran for civil court. And after completing a 10-year term, I then ran for Supreme Court and was successful. About 5.5 years into my judgeship in Supreme Court, I was elevated last July to serve as an Associate Justice of the Appellate Division of First Judicial Department, Supreme Court of the State of New York. And two quick stories. When I was at Corporation Counsel, I never forget that I had a supervisor who was an African-American woman who told me that I would be a judge. I laughed. And I laughed because I did not see myself in that position. That is why it is so important to speak into the lives of others so they can begin to see themselves in that role. I always say that in order to be it, you have to see it. So fast forward, I'm now working for a judge in Supreme Court. And I had another female judge, African-American, approach me. And it seemed interesting, but still I was a bit hesitant. This person reached out again. And at that time, I could visualize myself in the role and then threw my hat in the ring. Another quick tidbit, where I am now, the first department, I was participating in a panel and someone pulled me aside and said, did you ever think about serving in the appellate division? And I said, I never really gave it a thought. And the person said, would you be interested? I want to introduce you to someone. Well, the rest is history. I'm now on the appellate division. And let me just say that I'm also very active in a number of bar associations, judicial associations, including serving as past president of the National Association of Women Judges. And I'm going to talk about the role of bar associations, judicial associations, because they've certainly played a role in my personal development and also professional development. I like to say that opportunities happen when you show up. You have to show up. And we'll talk more about that. Can I just say one more thing? And I'll make it really quick. I had the pleasure of participating in a judges panel at your 47th annual meeting in DC back in September 2019, where we discussed our perspectives on what courts were doing to promote diversity with respect to younger lawyers as well in the courtroom. And I thank my friend Mercedes Meyer for introducing me to this organization. And also to you, IPO, for extending another invitation for me to share my thoughts on this noteworthy topic. I'm done, I promise. Thank you.
That's all right. Thank you for sharing, because I think that those kinds of personal stories end up being, I think, among the most meaningful for people who are listening and starting to wonder whether they might be able to see themselves in a role like this. So thank you, Justice Kennedy. Judge Bullock, tell us a little about your background.
Yes, well, thank you. So my name is Scott Bullock. I'm the Chief Judge of the Patent Trial and Appeal Board at the U.S. Patent and Trademark Office, as I think is given away by my backdrop here. And so we're an administrative tribunal. We have a more specialized role in looking at patent validity, but I've been at the board for about 14 years. Actually, law turns out to be my third career. I started out as a Navy officer on active duty. I was on a ship that literally went just about all around the world. We came very close to making ends meet. Then my second career was as a government contractor with a technology firm doing Navy radar system work. And then as in my legal career, I was very fortunate and honored to be able to clerk for Judge Schall on the Federal Circuit, work in a firm in Washington, D.C. Then I became a government patent attorney, working as a civilian for some Navy labs before I came to the office. And really throughout this, I've learned the importance of diversity and hearing from all people. I genuinely believe we're at our best when we hear from everybody and we have participation from everybody. And I've been really pleased and honored to be able to help in hiring judges at the PTAB, as well as helping to assemble a diverse senior leadership team here at the board. Again, I think that really benefits all of us when we have a diverse mix of people and experiences brought to bear in solving any problem, whatever it may be.
Well, thank you, Judge Bullock, as well, for being a part of the conversation today. Let's start with our own backyard. We know that the bench, whether we're talking about the trial of the appellate bench or whether we're talking about state, federal, or agency benches, that we do have a long way to go before the bench will fully reflect the diverse society. Part of the solution we've heard has to do with the pipeline of candidates and what we can do to enhance that pipeline. I'd like to hear from each of you about what you're seeing out there in the way of efforts to encourage diverse individuals to do what Justice Kennedy mentioned a moment ago, which is to see themselves, to think of themselves as candidates for the bench, either in the near term or down the road. So let me start with you, Judge OMalley. What are you seeing out there, and what do you think is working in the way of trying to improve that pipeline?
Well, there's a couple different responses. One is that with respect to what we can do personally, we are very limited to some extent because of the ethical limitations that we have. We can't openly endorse a particular candidate, but we can do exactly what Justice Kennedy mentioned, which is just to say, hey, have you ever thought about this? Why don't you pursue this? Or this is what I did to get my name out there. Here's some tips that you could follow. It has to be more subtle ways in which we personally can do it. The other point is that there are two different questions here. One is pipelines to the bench generally, and the other is pipelines to an IP focused bench. And they're different issues. Just like in 1993, I was one of the few women who were out there actually trying a lot of cases in the state of Ohio. In this day and age, there are not as many women or people of color who are involved in STEM or who are even interested in staying involved in, for instance, patent work. So there's a different kind of pipeline. We both have to there are lots of pipeline organizations, some of which are just aimed at people of color and people who come from disadvantaged backgrounds. And those are great. And a lot of the judges are using them for purposes of finding interns and even for purposes of finding law clerks. But we also need a pipeline that gets people interested in innovation, that gets people interested in STEM, that gets people interested in just the patent world generally. That's a little more difficult. And for me, that has to go way deep. In other words, we've got to start long before law school with respect to grooming people for that IP pipeline. So I think that there are lots of things that are being done, and certainly all of us in hiring law clerks, just like Judge Jones gave me a shot, even though I came from nowhere. He gave me the chance to be a law clerk, and it changed my career. I have tried to hire a panoply of diverse law clerks over the course of the years, and it's by just individual interaction with them that I can see them grow and flourish. And, you know, unfortunately, they're all out making a lot of money instead of seeking the bench right now. But hopefully they will, once they get that out of their system, they will do the same thing. So I think there's two different questions for this organization. One is the pipeline generally to all benches, and then the other is the pipeline as it relates to people interested in IP and who would be willing to develop an expertise in IP.
Let me ask Judge Bullock to the IP point in particular. Are there some things that you've seen from your vantage point that you think may be starting to bear fruit?
Well, yes, there are a number of efforts that we have, and certainly as far as recruiting judges to an administrative tribunal, it's a little different than the Article 3 bench. We hire through a more civil service process, but one of the things that we're doing is looking to try to make sure that we get our advertisements out to disseminate these announcements as widely as possible. So including, historically underrepresented groups. And we work with our Office of Equal Employment Opportunity and Diversity in trying to strategize how to reach those audiences. As an agency, the USPTO has a number of efforts that it does. There's an Office of Education that provides education and outreach programs for students and tries to reach younger inventors of all ages up through high school. We have an Office of Innovation Outreach that develops awareness and outreach programs to help train inventors, organizations, and universities that include various groups and including Asian, Black, Hispanic, LGBTQ, veteran, and women's organizations, mostly focused after high school. And as far as PTAB goes, again, part of our hiring, we do have a very small law clerk program. We have been hosting a hospitality suite at the Loyola Chicago Patent Law Interview Program, where we have interacted with a lot of clerks or clerk candidates, as well as law schools, to try to get the word out about our programs. So there are a number of things that we've been able to do as an agency and as a board.
On Hildy, on the IP specific thing, I would be remiss if I did not give a shout out to this very organization. I mean, I have often talked about and said in various speeches that I've given on this topic that I think the IPO foundations, education foundations work, which I've been watching now for years, is really important and a great model. They reach down to students. They try to teach even young students the importance of being an innovator, of being proud of their innovations, of sharing their expertise with others. And I have watched some amazing things from young people at these IPO events. So I'm not doing this just to be solicitous. I'm doing this because I truly believe that it's an important effort that this foundation is making.
Yeah, thank you. Justice Kennedy, but what about from your vantage point?
If I may, I just want to briefly comment on what Judge OMalley said when she said that we have to build the pipeline much earlier. And I believe that it starts at elementary school so that you can begin to plant the seeds. And just very briefly on the IP point, that there are a number of organizations. I'll just name one here in New York, and it may even be national, Girls Who Code. And I'm aware of various corporations partnering with Girls Who Code and similar type organizations, even my high school, Brooklyn Technical High School, which is one of the specialized high schools here in New York with respect to various opportunities. But one noteworthy effort that we have here in New York is spearheaded by the Franklin H. Williams Commission. And that's a court organization that promotes racial and ethnic fairness in the courts. And they have a judicial mentoring program so that attorneys who aspire to become a judge, they are partnered with a judge mentor to give them support and guidance with respect to how to apply to become a judge. And many of the judicial associations, for example, I believe it was the either the Latino Judges Association had a program very recently about how to become a judge. So many of the judicial organizations have these programs and they partner with bar associations. I think that's key, the partnership between judges and attorneys with respect to this effort.
And I would certainly echo that from my experience in the District of Minnesota. We've got a strong Minnesota chapter of the Federal Bar Association with a lot of involvement by both judges and practitioners. And so I know that for several years, the IP committee of that chapter has worked with the Girl Scouts in this region, and because there is an IP merit badge. And so judges and practicing lawyers get together on a Saturday morning with these young ladies ranging in age from, I think, 4th to 6th grade, talking about inventing and marketing and trademarks and copyrights and the creativity that gets turned loose and the light bulbs that go on when they not only think about that for themselves, but they see diverse lawyers and judges right in front of them and have role models to think about and to visualize. To get back to your point at the very beginning, Justice Kennedy, it's another opportunity. And I think we can all be thinking about where those entry points might be that would give us a chance to carry that message.
Can
Yes,
we all be honorary recipients of those merit badges?
There you go. Let me talk with the regional director and see what I can do along those lines. We've talked a little bit about, pipeline. Judge OMalley, you raised the question about, which I think may vary from organization to organization, about how far any individual judge is able to go in sort of sponsoring or advocating for someone. But I do think all of us have had the experience of mentoring in the sense of just sitting down over lunch with a lawyer. Maybe they approached you, maybe you approached them, to just pique their interest about the process. And Justice Kennedy, I was curious if you're sitting down over a lunch with a lawyer that maybe you reached out to, are there some tips you offer them, or some encouraging words that are sort of recurring themes for you?
That's a good question because I just had a Zoom maybe about a month ago with an attorney, and we met through one of the committees that I serve on. And very often there's just a certain chemistry where someone reaches out to you. And that's what happened in this case, where this person updates me on her progress, what she's doing now. And I just may, just give some thoughts for her to think about, what about this? What about that? But she is an outstanding young woman who's very focused. And it's just been a pleasure.
Mhm. Okay. Judge Bullock, if somebody approaches you and they're saying, you know, someday I'd maybe like to do what you're doing, are there some tips that you offer for how they might enhance their eventual candidacy?
Sure, and this is something that, I mean, we, talked to different groups. This was a little easier pre-COVID than it is now. Sometimes the Zoom interactions are a little less spontaneous, or sometimes harder to, connect more spontaneously with these groups. But I certainly, encourage them to look into these fields. I'm always on the lookout to encourage people to join the Patent and Trademark Office, and we have a whole bunch of different forms in which that can take place, either as an examiner, as a patent examiner, trademark examiner. We have legal positions in our solicitor's office and Office of General Counsel here at the board. And so I try to make people aware of the different paths they can go, as sometimes seems to happen with people in the earlier in their career. And I know Judge OMalley mentioned this, the amount of money one can make in private practice might delay their arrival to the agency. But I think at some point people really are seeking more meaningful work to do. And so I try to encourage them to think about the mission and what they can contribute. And try to point to a number of folks, if there are other judges at the board that I think they might be able to, if their stories seem similar, try to put them in contact. I mean, one thing that we're always mindful of is that representation matters, and that if you can see it, you can be it. And so that's something that I try to see if I can also facilitate other meetings, with a broader base of people, and then they can envision themselves maybe in that role someday.
Mhm. And I think the point you make about it, it's sort of the background and the path, and can you connect somebody with somebody who may have faced some similar challenges or has some comparable hurdles they overcame, or some commonality of background. I think that can give that conversation some traction.
Right. And I try to encourage people to be open to opportunity, because you never know where things are going to go, or when an opportunity arises, be open to it.
Yeah. Judge OMalley, are there some recurring themes that when somebody reaches out to you and says, someday I'd like to be a judge in general, or to do what you're doing in particular, what kind of advice do you find yourself offering?
Yeah, I find that I the older I get, the more I get these questions. And I get them not just from my own law clerks, but from other law clerks that work for other judges, or from lawyers. I get it from a variety of sources, and I'm always happy to talk or to do that virtual lunch, or an actual lunch or coffee when the world allows. But I think there are a couple things, and one is what Judge Bullock just mentioned, and that Justice Kennedy sort of mentioned as it relates to her own experiences, which is you have to be open. You have to. I never thought that I was going to leave the big firm. I had just made partner. I was making money. I had, a really nice house. I had the perfect nanny. I had to give up all of that and move and go work for the Ohio Attorney General. And one of the reasons I did is because people like Nate Jones called me and said, you are out of your mind. If you think you ever are going to be a judge, this is your best opportunity. You will have both the private experience, the public service experience. And so I opted to do something that I really, in my mind, wasn't sure I wanted to do. And it ended up being one of the best jobs ever, and being a great stepping stone for me. So I think it's very important that you don't chart a path for yourself and refuse to deviate from that. The other big piece of advice that I give to everyone is to don't be afraid to ask others for help. You can't just sit there and assume that someone is going to recognize how smart you are and walk up to you and say, here, let me hand you this judgeship. You know, as I learned early on, the federal bench is both big P and small p political, as much as running for office would be. So you have to go out there and you've got to seek help. You've got to talk to people. You've got to make your interests known. And the one thing that I found out in life is that the more you ask for help, the more those people that do help you become invested in your future. So once they help you once, they're like, well, I really want to see her go. I want to see her do better and better and better. And without you even asking the next time, they are there to champion your cause. So ask for help. Don't just sit back and be shy about it. Don't just assume that it's all going to come your way. And then if it does come your way, even if you don't think it's what you want, you need to be prepared to take the opportunity to broaden your background and broaden your experiences.
One of my first mentor as a lawyer, wonderful trial lawyer, his phrase was, you take pie when pie is passed. And because, you know, that plate may be empty by the time it comes around the table again. And that's one of the messages when people have asked me about, you know, how they might equip themselves to be credible candidates. It's be alive to the opportunity that broadens your experience. And Judge OMalley, I think your point as well about asking for help, because as often as not, if you don't say something to let people know you're interested, they won't think you are or won't realize you are. And it's a way of getting into people's minds that it might be something you'd like to do someday.
Judge, real quick, I just want to just comment on what Judge OMalley said. None of us got here on our own efforts. It was also because people helped us along the way. And that is so important, that we each have our own support network that we continue to benefit from. That's all I want to say.
Yeah, absolutely. Absolutely. Let's return to the chambers idea. And you've mentioned law clerks, you've mentioned interns and externs. Certainly one of the things that the federal judiciary has been looking at recently, I assume in the state and agency areas as well, is how can we increase diversity among our law clerks, among interns, among externs, and are there some things that people are doing to make sure they're looking at a broader pool of candidates? So Judge Bullock, you mentioned a little bit, but are there particular things that your agency does to make sure that it is getting as broad a pool of candidates and is taking a good hard look at them?
Yes, so as I mentioned, well, one of the things is that all of our positions are announced on the government's job website, the usajobs.gov. So that's accessible. But then, beyond that, as I mentioned, we do attend the Loyola Chicago patent law interview program. We've been in contact with law schools for our law clerk program, and we look to try to ensure that either certain bar groups or schools that might have a higher proportion of traditionally underrepresented groups get our advertisements, and we try to make sure to spread the awareness of these opportunities. So that's one of the things that we do to try to raise awareness externally for our job postings, and we've even started a committee internally. We last year stood up our own DEI committee to try to take a hard look at all of our advertising for jobs and really make sure that we're trying to get these the awareness of these jobs and the awareness of how to find these on the USA Jobs website, out to the various communities.
Judge OMalley, let me ask you as well. You indicated, or it sounded like you'd had some good success over the years in surrounding yourself with diverse law clerks. Were there particular things that you did deliberately, mindfully to make sure that you saw that pool?
I have to tell you, it was a lot harder at the district court when I first came on. I tried very hard to find good diverse candidates. I even reached out to Judge Jones and other African-American judges in the country to say, if you have candidates that you don't hire for the Court of Appeals, maybe they'd want to be on the district court. And a couple funny responses was, well, a really talented, minority candidate at this point in time, who is in a small pool, they can either get a Court of Appeals or even a Supreme Court clerkship, or they can go off and make money. And most of them don't want to live in Cleveland, Ohio. So I had a bit of a harder time. On the federal circuit, I have not had a hard time. All the list of minorities that Judge Bullock mentioned, I have had parade through my chambers and happily have had them. I think I did get perhaps a reputation of being, open to candidates who didn't necessarily just come from Harvard or Yale. I of course demand excellence, but you can get top candidates from other schools and then satisfy the diversity issue. So I've had, like I said, everything that Judge Bullock mentioned, and then some in terms of the kinds of candidates that I've had. The year of the pandemic, I found myself realizing I had an entire female chambers. All of my law clerks were female, and one was LGBTQ, and one was Pakistani, and we had just a whole spread of different participants from all different ranges. And so I have to say, I have to confess, I don't think I tried anything too specific other than being open to a different pool of candidates, a broader pool of candidates.
Yeah. Justice Kennedy, what about in the New York Supreme Court? Have there been specific initiatives, if you will, to increase the diversity of hiring when it comes to the chambers team?
Sure. Once again, I have to comment on something that Judge OMalley said. It's about broadening the pool, because very so often, and I think this may be more so for the federal judiciary, that the normal candidate is someone from your Ivy League schools, and excellence exists in other schools as well. So I think that is so important. Particularly, we've heard a lot about the HBCUs, historically Black colleges and universities. And you know who the leaders are. I don't have to tell you who they are, but a number of these HBCUs have law schools. Certainly, the Honorable Thurgood Marshall, U.S. Supreme Court Judge, Howard University alum. I can go on and on and on, but I think that's really important. It's about expanding the pool and not being so limited on the focus that excellence only occurs here. Excellence occurs in so many places, but with respect to New York, and I can also, talk about nationally, very often there may be outreach to say, all right, National Bar Association, that's the organization of judges of color throughout the nation. Do you have any candidates? With respect to Judicial Friends, that's an organization of judges of color throughout the state. Same thing, outreach goals there. With the affinity bar associations, with the law schools, and to say also, please make reference to the various affinity student organizations, BALSA, Black, Latino, Asian law students, the various LGBTQ. So it's a conscious effort to make sure that we cast a wide net, as well as the notices that are posted on the court website.
Yeah. Interesting question came in from one of the attendees. And my guess is that the answer is going to vary dramatically. The question is diversity considered by courts when there's an opening on the bench? In other words, are there diversity requirements for the courts themselves? And I suspect that answer is going to vary quite a bit depending on who's doing the picking, who's doing the appointing. But Judge OMalley, do you want to take a shot at responding to that very interesting question?
You know, I get that question a lot. They'll say, "Oh, is that the woman's seat, or is that the gay seat, or is that the or is that the African American seat?" I don't think there's such a thing, and I think it really turns on, at least at the federal level, who's doing the appointings. It's at the district court, it's basically a senatorial prerogative. So those senators have to have a real desire to satisfy diversity. I know that in Ohio, Sherrod Brown has been very big on that, as was Rob Portman. And so I think that either at the district court level with the senators who are involved, or at the Court of Appeals level, it's really up to the president. I mean, you see that this president has a huge commitment to diversity, as did President Obama. I think President Biden even more so. At President Trump, just the opposite. So it's really driven by that. The court can't dictate anything. We can certainly say, if someone calls and asks us, would it be nice to have, another X type of person on the bench, we can certainly say yes, but we can't influence that at all.
Judge Bullock, how would you answer that question from the USPTO?
So I guess what I would say is that our hiring process is similar to other hiring processes in the federal government, and certainly the federal government is committed to diversity and inclusion in our hiring. We don't have a mandate that there are, as Judge OMalley alluded to, that these seats are for this particular type of person, but overall the federal government and USPTO and PTAB are all committed to hiring diverse candidates for our jobs. And so it's something that I'm very pleased that we've had some success in being able to do.
Let's talk for a bit about what judges are doing to promote diversity and inclusion in terms of practice in our own courtrooms. And of course, we know that over the last year and a half, the very concept of what is a courtroom changed rather dramatically as we seemingly on a dime pivoted to virtual hearings. And I think that may have made a difference in how you might answer this question. But let me ask Justice Kennedy, what have you done, or what have you seen and heard among your colleagues about things they're doing to sort of raise up opportunities or to encourage opportunities for newer lawyers, diverse lawyers, to actually stand up and say something in the courtroom, as opposed to being the one passing the yellow sticky notes to their older colleague?
Judge, I'm going to have to answer that question as it relates to pre-COVID, because now in my current role, I just don't have that opportunity since we were virtual. We're now back in person, but it's a bit difficult. And remember, I'm still learning myself. So I'm going to answer the question as it relates to pre-COVID, but many of my colleagues have part rules. And within those part rules, they would encourage more senior lawyers to provide speaking opportunities to younger lawyers or those lawyers who are underrepresented. And I said this during our planning call that I was so inspired by the federal bench because they really took the lead on this, but particularly the late Honorable Jack Weinstein with respect to issuing these orders, suggesting, encouraging the use of junior attorneys. So I know that pre-COVID, many of my state court judges, particularly here in New York, encouraged that, talked about the importance. And just one real quick story, I never forget that when I had a motion calendar, and let's just say that there was a female there, everyone else was male, and she was, junior. And I just slightly, posed the question, oh, is Miss so-and-so going to address the court? Things like that.
Judge Bullock, are there some things that your organization has done to try to raise opportunities or encourage opportunities for newer practitioners before you?
Yes, we have a program that was sort of, had its genesis, or its inspiration, in those programs that Justice Kennedy described that were in the district courts, encouraging, younger, less experienced practitioners to get stand-up time. So our program is called LEAP at the USPTO. And that stands for the Legal Experience and Advancement Program. And what it is designed to do is broaden the base of attorneys who get stand-up speaking time at our oral arguments, both in our trials and our appeals. It incentivizes this by providing extra oral argument time if you have a LEAP practitioner. The way that we've defined LEAP practitioners, we actually just last month expanded the definition because originally we had a 7-year or less time in practice. What we found is that was excluding people who had different experiences, such as taking time off to raise a family, or maybe had come from a different area of practice into intellectual property, or had gone on military service, that sort of thing. So we recently just scrapped the 7-year requirement. So our requirement is 3 or fewer stand-up arguments in the federal courts. And so, but what this does is it gives an extra 15 minutes, which, considering that most of our arguments are about an hour in trials or 20 minutes in appeals, gives an expanded opportunity to talk. We also designed a feature based on some feedback that we got in talking to folks who had set up the district court programs and organizations like CHIPS and NextGen. We had a way that a more experienced counsel can help correct record or lend assistance if it's needed. Generally it's not needed because the LEAP practitioners are the ones who are closest to the record, who have actually been developing the arguments and helping to write the briefs. So generally it's not needed, but in order to help provide clients with a little more comfort in allowing these practitioners to stand up and speak, we do allow a more experienced practitioner to lend us a hand if that becomes necessary. We also established a training program that has both a classroom component. We have seminars that we put on about oral argument and about the board in general, practice before the board, our trial and our appeals jurisdictions. And we've had a number of practicums so far, which are really mock oral arguments. So we've had, I think we've had about 4 mock oral arguments. We're going to have another one sometime in the spring where we have actual judges from the board serve as our panelists, and then we set up teams of attorneys to do their mock argument. And we set it up in a way so that essentially nobody from their firm is in that mock argument room, so they can feel free to try things out without being judged, or if they make a mistake, we think that's the best place to make it, where there's really no consequence. They can learn and take that back. And so far, since we've had the program, we've had about 84 practitioners make arguments in our proceedings. It's sort of spread between the appeals and the trials. About a third have been in our appeals, and about 2/3 have been in our trials. So we're very happy with this, but we do try to promote this. One thing that we found is that if we stop talking about it, the participation goes down. And every time we talk about it, the participation goes up. So especially to organizations like IPO, who may be in a position to encourage folks to do that, we always want to put in a plug for our LEAP program, and please encourage attorneys to participate.
Yeah. Judge OMalley, anything like that happen at the federal circuit?
Well, I think, as Justice Kennedy said, the district court level, the federal courts have really been out front on this. I think of Barbara Lynn in Texas, who, like Jack Weinstein, is really aggressive about giving opportunities. I mean, the beauty is with the district court, we don't have to have, or I didn't, they don't have to have arguments on every single motion. So not even summary judgment motions. So Barbara will say, I think I could handle this without an argument, but if you want an argument, I'll give it to you as long as somebody's 7 years or less, or some other criteria that she'll put in place to give young people an opportunity. And otherwise, we don't need argument. And so almost everybody takes her up on that because they'd rather have the chance at an argument. We have to be a little more subtle because we hear argument in every lawyer's case. So we can't say, like, some court of appeals could do it because could do this because they don't hear argument in every case, but we do. So we can't say you're not going to get an argument because everybody knows they are. But we can encourage use of younger people in situations like this. We can also be a little kinder and gentler to the younger candidates that are arguing. For instance, if somebody is really stumped, normally we would push them really hard, and instead we might say, well, why don't you sit down and think about that? And then on rebuttal, tell us where that is in the record. And obviously that means they can ask the person that's sitting at the table with them. But Judge Bullock's point is also a very good one. Our judges are really very good about participating in mock arguments, about being the actual judges for students. And the Giles Rich has a national program. Several other organizations have national mock trial programs, even particularly in the IP space, or the American Academy of Trial Lawyers has a program at the trial level for mock trials. And by, I think, our judges being willing to participate in those, to show them, and we show them a very real experience. We're not being soft on them in that circumstance. We are trying to teach them. And some of the lawyers that I've seen and third-year law students at some of these programs are as good as anything that we normally would see. And it's very impressive. And so I think it's important that we all continue to do that.
I would put in a plug too for mock arguments in front of the client. I mean, again, to echo your comment at the very beginning, Justice Kennedy, part of it is, can the person see themselves? But it also is, can the client see them? Because ultimately it is up to the client. And I know that everybody's running on budgets, but to the extent that the law firm and the client can sort of partner, or even the law firm, defray the cost of, or eat the cost of that mock argument, so that the client, who ultimately has to make the decision about who argues that issue on Markman, can see how well this person does. I think that ends up being huge. But we have another interesting question from the audience. Can the judges speak to how a diverse panel of attorneys could interpret novelty of an invention disclosure differently compared to a non-diverse panel? Your response could be based on experience or based on theory. So can this, how a diverse panel of attorneys could interpret novelty of an invention disclosure differently as opposed to a non-diverse group? Judge Bullock or Judge OMalley, any thoughts on that?
Judge Bullock, you can go first. I have.
Okay, all right. Thank you. So my thought on this, and I'm not sure if this is really getting to the answer the questioner is asking, but in my mind, what the diverse panel of attorneys brings is that diversity of experience and viewpoints, that they might be able to come up with a more holistic understanding of the invention and of the prior art than somebody who just had a single viewpoint or single set of experiences. And so, in my mind, I don't know if it necessarily comes out differently, as it were, but I think it is a more complete understanding, and certainly making sure that you've checked it from all sides. So that would be my answer to the question.
And therefore perhaps more confidence in the
right. I think it increases your confidence that you got it right, because you've heard from people with differing viewpoints.
Yeah. Anyone else want to address that?
I kiddingly always say that, of course you have to have women on the panel because they're far more logical than men. But I do think that Judge Bullock has it exactly right. It's the everything we do as judges is colored by our own experiences. We can't pretend that it really is as black and white as the world thinks. And even with what you think one of skill in the art would understand, for instance, from written description, you bring to that some common sense. And so I think that having different experiences and people who see things differently, I mean, if all you had is three people who had one set of scientific backgrounds and all had exactly the same socioeconomic background, they're going to look at it with a very stilted view, I think. And so I think it's good to have a variety of viewpoints to look at the world and to look at the problem presented in front of it, even if it's a patent law problem.
Yeah, I agree with everything that Judges Boalick and OMalley has said. And it really doesn't matter what type of case it is. Judge Boalick's answer applies across the board. The same thing with Judge OMalley. But two things I want to add to that there is a plethora of research. Now, do I have the statistics? No. But there's a plethora of research that indicates that a diverse bench leads to better decision making. This is the same thing with corporations as well. It's better for the bottom line. But lastly, I believe that diversity is an access to justice issue. And when people see judges that are truly reflective of the community, it gives them a greater confidence and respect for the judiciary, which in turn also further promotes the rule of law. Because right now we're in tenuous territory with that, with let's just say, confidence in the judiciary, and I'll leave it at that.
And
That's putting it mildly.
I can't think of a better note on which to end this conversation. Thank you to Judge OMalley, Justice Kennedy, Judge Bullock, for a delightful conversation. I hope our audience has enjoyed it as much as I have. Thank you all for your time.